All right, good evening, folks. Welcome to Monday Night Law on Kirk's Law Corner. How's everybody doing on this? Oof, I hate even Halloween. Some people are totally oblivious to what Halloween is about, but nonetheless, it is a holiday, I guess. Anyways, hope everybody's having a wonderful evening. Had a good weekend, had a good week. So I wanted to cover a few things tonight. One, about the status of national and how people talk about changing their status. So, again, I'm going to throw this out there, some law, of course, and I don't know, kind of go down the rabbit hole on this, and then get into some older documents of our Republican form of government, and the statuses within our Republican form of government, and we will find that, technically speaking, there's no such thing as national in the sense of changing your status to being a national. Those are not the statuses within our Republican form of government that our founders created. So, good evening, Jax. How are you? Thomas, good to see you. Thanks for your support over there on Patreon. And for the rest of y'all over there that have recently joined Patreon, thank you. Just want to let everybody know we are broadcasting live on Rumble, Telegram, Facebook, my page, and YouTube. So right now, 4 of many different platforms. I'm still not able to go live on Getter or any of that. And then for those that want to help support, because, PayPal and Cash App, they took me down over a year ago. So, what's up, brother Michael? Good to see you. Thanks, brother. How people can help support, because I keep getting messages. How can I send you some? You got PayPal? You got what do you Venmo is through PayPal, so they took down the Venmo. So the best way to support me right now is through Patreon. Now, Tier 1, Tier 2 essentially are my supporters out there that want to make a monthly donation of $5 to $10 a month. Okay, there has been a change to Patreon, but Tier 3 is $50 a month, and that gets you into the Wednesday night workshop. It is a private workshop where I do private teachings, education, obviously, and try to curtail some of my teachings to particular things that are going on with the patrons themselves. And then, of course, Tier 4 is for one-on-ones, which is $100. Basically, it's for 1 hour per month. Now, one of the things that have changed with Patreon is they've changed the date of taking the money out from the first of the month to those who, when you join now, it immediately comes out. So, for those that had issues before, like, oh man, can you change it? I have no control over any of that. I have no access to any of your banking information. I have no control over how Patreon does its billing. I don't even get to see your real name or any of that. So, anyways, you can change your date of cycling. I think if you were to cancel and then resubscribe. So for those of you that have a hard time at the beginning of the month, you could go over to, say, the 15th of the month. So you would just cancel your membership and start a new subscription there on the 15th. So the other nice thing about what they've changed is I can now upload videos onto Patreon. So Wednesday night workshop videos, I will start uploading those for the tier 3 and tier 4 members, patrons there. So you'll be able to watch it through Patreon. And I want to let people know that I do all my communications regarding Patreon through Patreon, not through YouTube or not through Telegram, not through anywhere else. Patreon is Patreon and Patreon only. It's kind of a lot like a social media platform. I mean, you have where your messages are at there. They even have an app that you can put on your Android or your iPhone, so you can download the app and go through the app, or you can just go straight to the web and go through the web and use the interface on the web. So all of that is all right there on Patreon itself. So again, I'd like to thank those that have subscribed over there and being a part of that, what's going on over there. We got quite a few people on the Wednesday night workshop, going good. Talk to people that are currently in there. You'll see some of their comments here. It's always good stuff, right? And we get into quite a bit of different things, especially when we kind of just open things up for general questions and talking. Definitely things that we can't talk about on here, at least on Facebook or YouTube. I don't know about Rumble or Telegram, but don't seem to have a problem there yet. So, without further ado, let's jump into the word national. And I like to go to the root of things, okay? So we're going to get into etymology. Oh, I thought I had that pulled up already. I did. But it's over here. Because etymology is the origin of words. And it does break things down and more of a history and where those words come from, especially when we're talking like the English language, which is a newer language, right? It's not, we're talking Old French or Latin, right? And they come into, translated into another language. So we're going to start with the word national in etymology. And it's an adjective. It's not necessarily a noun, although it talks about as a noun, which we'll get to there in a second. So, national, as an adjective, of or pertaining to a nation or country regarded as a whole. Wait a minute. As a whole? Well, how is that? Yeah, do a little fixing here. So you excuse me for just a second as I fix this on. There we go, I think. No, not quite. Okay. There, that should be a little better. Established and maintained by the nation. Peculiar to the whole people of a country is from 1590s, from French national, 16th century from Old French, nation. I don't speak French. In fact, I barely speak English. So, and also from nation plus all, opposed to local or provincial, or in the U.S., state. Meaning, particular or common to the whole people of a country is by 1620s, from 1802. Okay, now we're talking 1802, which is after 1776. Established and maintained by the nation or its laws. Now we get into as a noun. Now, as a noun, as we can see here, is citizen of a particular nation. Is from 1887. Now notice the date of that is after the Reconstruction Acts of 1881. So prior to 1887, we didn't have a national in the sense of as a citizen of a particular nation. And I'm going to show you where that comes from and why and where that came from in 1887 and where it's found in the Public Law or United States Code and under what subject matter. National Guards from 1793, originally in reference to the armed force in France identified with the Revolution. U.S. use is from 1847. Originally, and this is National Guard, originally a name sometimes given to the organized militia. Organized by the state. A well-regulated militia is the organized by state or federal military. National is recorded at 1806. A king, though he's pestered with cares, for the most part, he's able to ban them. But one comes in a shape he never can escape. The implacable national anthem. His Excellency in 1894, W.S. Gilbert. Now we're getting into some other parts of this national, but there's one that I kind of want to get into here is a nationalist, which is actually what Trump called himself. He came out and said he was a nationalist. He didn't say he was a national. He said he was a nationalist. And they took that and said, oh, see, look, he said he's a nationalist, talking about how that's bad, right? Trying to twist it and what it really means. But it's one devoted to his nation. Now, let's get into that particular part there. What the heck is our nation here? America is our nation. Now we'll find here shortly when we get into the Law of Nations that the territory, landmass, the territorial landmass known as North America. Now within that territorial landmass, there is landmasses as a territory known as the nation called America. Now, within the Articles of Confederation, we actually included Canada. You read the Articles of Confederation, it talks about our friends from Canada. Is part of the nation as an ideology. Because you have to declare the law of the nation. So, how are we not grasping the concept of what a nation state is? And we'll get to that here in a minute with the Law of Nations. So, one devoted to his nation is 1715, clearly before 1776. From national, as an adjective, in a now otherwise obsolete sense of patriotic, characterized by attachment or devotion to one's own race, or country, or its institutions is 1711. Okay? So, we can see a timeline here in correlation to the creation of our nation. In the 19th century, which is 1800, Britain, often particularly one who advocates independence for a nation, is a nationalist, especially Ireland. Okay, also used in theology for one who holds the divine election of entire nations. As distinguished from that of particular individuals is 1836. A nationalist is distinguished from that of the particular individuals. Something seems a little off there, but as in bad. How they want to portray themselves like the king, right? One who holds to the divine election of entire nations. Okay, so there's your etymology. But let's go back up. As a noun, we're talking as a noun now, right? Because person, place, or thing. Person, not man. Person. So what are we looking at here? Citizen of a nation. So what is citizen? Because that's the person. It's definitely not a place, and it's not really a thing. And remember, persons are, technically speaking, an individual or corporation. And it's, an entity. So now we could go over here. We could just do it right here for just a second. See what a citizen is in etymology. As a noun. From clear back in 1300. Inhabitant of a city or town. Inhabitant. Okay. From Anglo-French citizen, city dweller, town dweller, citizen. So you're from the city as a citizen. Right? From city, like policy. See how in old language, how we get into E, like police. No, it's policy. City, A-E-I-O-U, sometimes Y. And there it is. Before we started using Y in the English language, it was cit-E, policy. Okay, according to Middle English Compendium, the S and the Z in Anglo-French presumably replaced the earlier TH. Okay, Old English words were... Alright, so sense of free man or inhabitant of a country. So, free inhabitant of a country. Then their other part here is a member of the state or nation, not an alien. Now, these are where we're going to be talking about the differences between a citizen. And we can see one is an inhabitant and one is a member. Again, remember these key words. Member. Okay. Free man or free inhabitant, or just inhabitant and member, because this is diction, jurisdiction. The words we use put us under what body of law? Okay. So we look at someone who's not an alien would be foreign, right? Foreign to the country or foreign to the nation state, meaning private person as opposed to a civil officer or soldier is from 1600. Private person. So as a title from 1795, from French during the French rulers, citoyen, was used as a Republican alternative to Monsieur. Citizen's arrest, one carried out by a private person without a warrant, allowable in certain cases, is recorded from 1941. Citizen's ban radio, 1947, Citizen of the World, late 15th century, translates Latin civum totius mundi. Again, I don't speak Latin. I really don't speak any other languages, so please forgive me if I butcher these. For those of you out there that actually have studied and learned these other languages and are just cringing, I apologize. I'm not even going to try and go with that one in Greek. So he is not a citizen who is not disposed to respect the laws and to obey the civil magistrate. He is certainly not a good citizen who does not wish to promote, by every means in his power, the welfare of the whole society of his fellow citizens. Adam Smith's Theory of Moral Sentiments. So there it is being used kind of in a sentence. Citizenry, citizens collectively, citizenship, status, rights, privileges, and responsibilities of a citizen is from 1610s, from citizenship. Where here we just say cit is an inhabitant of a city. Short name, citizen of London, contrasted to country, as contrasted to a country man or gentleman, usually with some measure of opprobrium. Johnson defines it as a pert, low townsman, pragmatical trader. I think that's pretty good to go down the little bit of a rabbit hole on a citizen. But it's right here. Free man or inhabitant of a country or member of the state or nation. Okay. So let's go over here. Let me see what's going on here. All right, so I have to... Okay. Making sure Telegram is working over there. We're going to go to Law of Nations. Now, some of you may remember this already, but we're putting this all together and going down the rabbit hole. And essentially, I'm going to challenge any man out there who claims that we need to change our status to a national and who is pushing this garbage. So this is Book 1, Chapter 19, subsection 211 to start with. Okay, and this is the Law of Nations, or the Principles of the Law of Nature, written by Emery Vattel, early 1700s. All right, now we're going to start right here at the beginning because this is great, where we get into country. The whole, see, this is what is our country. The whole of the countries possessed by a nation, and subject to its laws. Now, this is where I get into Idaho is a country. As we're going to read below about how the children follow the conditions of the father, and they are from the country from where their father comes from. Why do we do birth certificates and say, where were you born? I was born in Idaho, or I was born in California, or I was born in Nevada, or I was born in... Because those are the countries in the nation called America. So the entire territorial landmass makes up of America all of the countries. Even like Guam is still part of the nation. It's just not a settled nation state, which has a independent body politic. which we'll go back up and read that here in a minute. So the whole of the countries possessed by a nation is subject to its laws, forms, like form of government, legislative branch, executive branch, and judicial branch. That's part of our form of government. As we have already said, it's territory and is the common country of all the individuals of the nation. We have been obliged to anticipate the definition of the term native country in section 122 above, which we can go up to that. Because our subject led us to treat of the love of our country, a virtue so excellent and so necessary in a state. Supposing then this definition already known, it remains that we should explain several things that have a relation to this subject and answer the questions that naturally arise from it. Now this is where we get into section 212. As citizens, this is the definitions being defined here in the Law of Nations. And again, this is the section that the Constitution refers to as the president must be a natural-born citizen. This is where it comes from. This is the proper citation of what the definition of a natural-born citizen is, pursuant to the Constitution as it is written. So, the citizens are the members of the civil society, bound to this society by certain duties, and subject to its authority. They equally participate in its advantages. All right. So, things that Chris and I used to teach about. Emolument. Any advantage, profit, or gain received due to one's position of employment or holding of office. Advantages. Those emoluments of the offices have certain duties that they are bound by. This is where we go to the Constitution itself. Where is it? I've showed this before, but we really need to pay attention. We got to pull this together. Those words have meanings. And this is Article 6, Clause 1, Clause 2, and Clause 3. The senators and representatives before mentioned, and the members of the several state legislatures and all executive and judicial officers, both of the United States and of the several states, shall be bound by oath or affirmation to support this Constitution. Member of the state or nation is a citizen. See them words? Member. Because that's what an individual is a member of something. Like employee is an individual member of the corporation, the business. So, all of them, every last one of them are members. Back to an emolument, any advantage, profit, or gain are received due to one's position of employment or holding of office. So we have right here, but no religious test shall ever be required as a qualification to any office or public trust under the United States. So you can be elected into office or appointed into a position of public trust. So, like in our form of government, how we have the basic layout of the form of the government, and then the legislature creates, like for Idaho, other departments, is limited by to creating no more than 20 departments. Now, we have people who are appointed into a position of public trust, as the head of those departments. They're not elected officials. In my mind, they should be. But this is how it is right now. Okay? So we have to comprehend these words and what they mean and how it applies to our Republican form of government. Now I'm going to go over here to Article 6, Clause 2 part, right? And this seems to be quite a bit of confusion here with certain people, some people out there that want to talk about, well, yeah, but Congress made it. But let's read this. This Constitution and the laws of the United States which shall be made in pursuance thereof. Pursuant to this Constitution, and we're talking laws. And all treaties made or which shall be made under. Well, they made a treaty. Was it under the authority from this Constitution? That's the question you need to ask yourself. Shall be the supreme law of the land. All right. So now that we comprehend law of the land, and enactments of the legislature are not law of the land. So what we're talking about here is what's made pursuant to is through the Article 5 Convention as law of the United States or law of the land. Now notice what it says here next. And this is so vital, right? We talk about Marbury versus Madison. We don't need Marbury versus Madison because it says what it says as it is written right here. And the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary are not withstanding, which means there's no standing at law or in law. And this would be in law. This is all about in law. Right? Article 3, Section 2 suits in law, not suits at common law. So, we have to look at this here and comprehend what this means. What is the supreme law of the land? Because it's supreme. Now this is where we got, oh, well, the Bill of Rights doesn't apply to the states except for by and through the 14th Amendment. I believe the Bill of Rights stands as its own document, and as it is written there, it says that these are articles in addition to an amendment to the Constitution. It's an amendment, which was done through Article 5, which makes it part of the supreme law of the land. And then again, who made it? The states did, just like this Constitution was made by the states. Through a convention, a constitutional convention. A convention of states. All of the representatives of the states were delegates sent. See, back then, they did it properly. They were not actually elected officials. Delegates were sent. They were selected by the people themselves, or actually the representatives selected delegates from the pool of the people and sent them to represent them in Congress. That's how it's supposed to be done. But see, our form of government's been fundamentally altered. But here we are. This is how it's supposed to have been done in a convention. And it has to be submitted to the states, and then the people of the states ratify that. And that's how that came about with the Bill of Rights. So any man who makes the argument that the Bill of Rights does not apply to the states except for by and through the 14th Amendment, they're full of it. They're trying to pull the wool over your eyes and say, well, they're trying to do exactly what the 9th Amendment says that they're not supposed to do. And it's not amendment. These are articles. But see, they list here, 9th Amendment. No. The whole Bill of Rights was an amendment. The enumeration in the Constitution, of certain rights shall not be construed to deny or disparage others retained by the people. How is the Bill of Rights referring to the Constitution if it's not applicable to the states, when we know that the Constitution for the United States of America is most definitely applicable to the states? But this is the entire nation, right? This would be the national Constitution, which Article 4, Section 3 there gives Congress the power to admit new states into the Union. So how does it not apply to the states? The Ninth Amendment was James Madison's attempt to ensure that the Bill of Rights was not seen as granting to the people of the United States only the specific rights it addressed. In recent years, some have interpreted it as affirming the existence of such unenumerated rights outside those expressly protected by the Bill of Rights. That's because when we go back to American jurisprudence, right? Volume 16, Constitutional Law, Section 100. And this is August of 2017 update. This isn't old stuff. This is relatively new. This is when I went down. People ask, where can I get this at? Law Library. Or you can get a subscription to Westlaw or LexisNexis. Okay? But I went down to the Law Library, because that's what I've done for many, 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 many years, since 1995. I visit the Law Library to do a lot of research, to do some really good reading. Okay? But this is Section 100 generally. When we talk about a constitution, it's usually a declaration of principles of the fundamental law, many of its provisions being only commands to the legislature to enact laws, to carry out the purposes of the framers of the Constitution, or mere restrictions upon the power of the legislature to pass laws. Okay? But let's jump down here to the observation. Even without the benefit of a declaration that they are self-executing, because what we're actually referring to here is Section 97, 98, and 99, which has to do with the words shall and that kind of stuff. So, but what we're talking about here is whether or not a declaration that they are self-executing constitutional provisions in bills of rights. Wait. Are we saying that the Bill of Rights is a constitutional provision? It is, because it was done in convention. And it is, in fact, an amendment to the Constitution. So it is, in fact, part of the Constitution. Even though it's a standalone document as a Bill of Rights, a Declaration of Rights, let's read what it says here. Constitution provisions in bills of rights, and those merely, what? Declaratory of the common law, are usually considered self-executing, as our provision would specifically prohibit particular conduct. So this particular Bill of Rights is in fact nothing but merely declaratory of the common law. It's already the law. Period. Rights are the law. That government was instituted to secure these rights. Right? Declaration of Independence. That to secure these rights, governments are instituted. So rights come first, because that comes from the law of nature. Now, let's go back to the law of nations here, and we'll continue reading. Now that we know what a citizen is per our Constitution, and per the definition, international law, citizens are members of the civil society. That's what it gets created. That is bound to this society by certain duties and subject to its authority. This is where we have to comprehend subject matter, personal jurisdiction and subject matter jurisdiction. If you're not a member of McDonald's, does McDonald's policy apply to anybody else? No, because you're not a member. You're not an individual. You don't have a contract of employment with them. Therefore, none of McDonald's policy applies to the people, to man, to free inhabitants. Okay? So, if you're not a member of this civil society, the Constitution, and you haven't taken that oath of office and are bound by it to perform certain duties under the emoluments of that office that's created by the Constitution or pursuant to the Constitution, you're not a citizen. Not in the true sense of what a citizen really is. But again, this is a status. Okay? They equally participate in its advantages. The natives or natural-born citizens are those born in the country of parents who are citizens. As the society cannot exist and perpetuate itself other than the children of the citizen. Wait a minute, what does that say again? As the society cannot exist and perpetuate itself otherwise than by the children of the citizens. Those children naturally follow the condition of their fathers, because that's the common law, the law of nations, the law of nature, and succeed to all their rights. The society is supposed to desire this in consequence of what it owes to its own preservation. And it is presumed, as a matter of course, that each citizen on entering into society reserves to his children the right of becoming members of it. The country of the fathers is therefore that of the children, and these become true citizens merely by their tacit consent. We shall soon see whether on their coming of the years of discretion they may renounce their right and what they owe to the society in which they were born. I say that in order to be of the country, it is necessary that a person be born of a father who is a citizen. For if he is born there of a foreigner, it will be only the place of his birth and not his country. Okay. Now we're going to get into section 213 here. This is where we get to them inhabitants, as distinguished from citizens or foreigners who are permitted to settle and stay in the country. Bound to the society by their residence, they are subject to the laws of the state while they reside in it, and they are obliged to defend it because it grants them protection, though they do not participate in all the rights of citizens, like political power. They enjoy only the advantages which the law or customs gives them. Now, in our form of government, the way our founders created our form of government, we have a common law. And throughout history, going even clear back to the Magna Carta, even clear back to 600 AD, trying to get away from the Roman civil law, the Roman Empire. Remember the fall of the Roman Empire in 600 AD? And then this Roman civil law resurfaced there in early 1100s, which brought about the Magna Carta, because they tried to bring this Roman civil law back under Catholicism. That the church, Roman Catholic Church, gets to dictate what you can and can't do. And the people had enough in 1215 and stood up, said, no, we're tired of your Catholicism. We want to be the good Christian people that the Bible talks about, that Jesus talks about. No. We're separating from you. Right? We have these God-given rights and you're trampling on them. Liberty was born in 1215. It is the Great Charter of Liberty, setting mankind free, separating from the Roman Catholic Church, because that's what it says in the Magna Carta. The perpetual inhabitants are those who have received the right of perpetual residence. These are a kind of citizens of an inferior order and are united to the society without participating in all of its advantages. Their children follow the condition of the fathers, and as the state has given to these the right of perpetual residence, the right passes to their posterity. So, think about this. The founders are reading this stuff, and they knew this stuff back then, but this was put down in writing so that the whole world would know. Okay? So what did they create here in our Republican form of government? I mean, we look at the Articles of Confederation as inhabitants, free inhabitants, so they knew that term right from here. And then we have people, and then we have citizens. Those are the three statuses. Free inhabitants is man. And then you have the people who have all political power. All of it. So when we go back up here and look to those different forms of government, Book 1, Chapter 1, Section 3, oh, that's the preface. I went just a little too far. Oh boy, did I go too far. We want to go right to the very beginning, Book 1, Chapter 1. We're at Book 1, Chapter 3, so we'll be right there. Okay, right here, Book 1, Section 1, Book 1, Chapter 1, Section 3. Of the several kinds of government, if the body of the nation keeps in its own hands the empire or the right to command, it is a popular government, a democracy. All right. For those of you that caught the me as a guest there, Patricia Klein out there in New Jersey, and her early morning radio show, which was 6 o'clock in the morning for me, Saturday morning. I posted that over there on Telegram, and it is on my Facebook too. We covered a little bit about the difference between a republic and a democracy. So let's look at this again, because this is what I read from there. Same thing. If it entrusts to a certain number of citizens to a Senate. See how the citizens are the members of the Senate? It establishes an aristocratic republic. Then finally, if it confides the government to a single person, the state becomes a monarchy. Now remember, the state is the state of being, right? A nation or state is, or has been said at the beginning of this work, a body politic, or a society of men united together for the purpose of promoting their mutual safety and advantage by their combined strength. The country is the territorial landmass. The state is the state of being. The law of nation, and then you have the state as the body politic, the sovereign body who has the power to create. All right. from the very design that induces a number of men, a number of men, like a quorum, to form a society which has its common interests and which is to act in concert, it is necessary that there should be established a public authority. Public authority, not private authority, public. To order and direct is what is to be done by each in relation to the end of that association. So this is bound by certain duties. This political authority is the sovereignty, and he or they who are invested with it are the sovereign. Because the sovereign has the power to create. So we're looking at the form of our government. Our founders created. The statuses, they separated and said, no, we're tired of having the king and parliament dictating to the free inhabitants or even the people. Right? Erecting a multitude of new offices, sending hither swarms of officers to harass our people and eat out their substance. These police forces, these armed bodies of men, during times of peace. No standing armies. That's where that comes from. That's a whole nother show. The authority of the body politic over the members. So it is evident that by the very act of the civil or political, see, when we're talking that civil society, is the contract of employment or holding of office that they're required to be bound by. The Constitution is the compact. Some say it's a social compact, which it is, but in essence, it's a contract of employment. These are the terms and conditions of the emoluments of the offices that are created by the people as a form of government. And people retained their sovereignty. Smart move. Remember, those three types of government there at the time. Okay. It is evident that by the very act of the civil or political association, each citizen subjects himself to the authority of the entire body in everything that relates to the common welfare. Okay? The authority of all over each member, therefore, essentially belongs to the body politic or state. But the exercise of that authority may be placed in different hands according as the society may have ordained. That's why it says ordained or established. Law is that which is laid down. Declarations lay down the law. Ordained or established. That's Black's Law Dictionary. 4th edition. Law. That which is laid down, ordained, or established. So, the Constitution is ordained and established. Because ordained is the sovereign body. And then back to the section 3, right? These three kinds of government may be variously combined and modified. And then we shall not here enter into the particulars, okay? The subject belonging to the public universal law for the object of the present work. So, again, our founders, even starting with 1215 with the Magna Carta, really started trying to separate from this monarchy or the Roman Empire as a democracy and why we are not a democracy. Okay? We're a republic. And we're a confederate republic because that's the union of states. Freedom of religion. Okay? Now, there was one that was mentioning Section 102 and Section 120 from before, so I want to kind of see what that one referenced. I didn't just blow past it. Nope. $66, $80. Okay, here we go. We're close. Or was it 122? But I know there was a 102. See, this is how you do research. You got to go down the rabbit hole on certain things. It says, oh yeah, we referenced this above. 101, duty of government in this respect. 102, its rights in this respect. The whole nation ought doubtless to contribute to such useful undertakings, when therefore the laying out and repairing of highways, bridges, and canals would be too great a burden on the ordinary revenues of the state, the government may oblige the people to labor at them or to contribute to the expense. The peasants in some of these provinces of France have been heard to murmur at the laborers imposed upon them for the construction of roads, but experience had no sooner made them sensible of their true interest than they blessed the authors of the undertaking. Forced labor. All right. I want to go down to 120, I think it was, or 122, that down there was talking about citizen. And we'll know the correlation here in just a second. $115. I mean, this Law of Nations is just loaded with a plethora of knowledge and information. A love for their country. Remember, that was part of what was being talked about down there. The grand secret of giving to the virtues of individuals. It turns so advantageous. See how references section 53 above. The love of their country is natural to all men. The good and wise author of nature has taken care to bind them by a kind of instinct to the places where they receive their first breath, and they love their own nation as a thing with which they are intimately connected. Ooh, 120. In individuals, the love and affection of man feels for the state of which he is a member is a necessary consequence of the wise and rational love he owes to himself, since his own happiness is connected with that of his country. This sensation ought also to flow from the engagements he has entered into with society. Engagements as contracts. He has promised to procure its safety and advantage as far as in his power. And how can we serve it with zeal, fidelity, or courage if he has not a real love for it, our country, our nation? So, we're supposed to have the love of our country. And again, our founders, they went through quite a bit, so they knew essentially how to cut the tyrants out, how to get away from this Catholicism. And that's what they created in 1776 with the Virginia Constitution, June 29th, 1776. And this is how it applies here, is that, okay, you free inhabitants, you're not an elected official or appointed in a position of public trust. You're a free inhabitant or one of the people, right? But every able-bodied male is automatically in the unorganized by state or federal militia, duty bound. So there are some duties being an American, right? Because that's essentially what we are. We're just Americans. And I'm from the country of Idaho, in America, the nation. Okay? So, now that we kind of have a much broader understanding of who the citizens are, and yes, a free inhabitant is in a sense a citizen, but not in the sense of what we have here, and who is bound by the Constitution, because the people aren't even bound by the Constitution. The people create the instrument of government, and from the body of the people, that's where we elect qualified electors. So you have to qualify as an elector. You have to be one of the people. So people want to talk, men and women out there want to talk about changing your status. The real change of status is from man to one of the people. Now remember, to be one of the people, there's certain qualifications like, I don't know, a business owner, because you're a taxpayer. You become the employer. You're paying the wages of the emoluments of the offices created. Okay? So, now we're going to go over here just a little bit back to some history here, and then, of course, United States Code. A national of the United States. Now remember, that was when? 1887? Or was it 1878? The term national of the United States means a citizen of the United States, or B, a person who, though not a citizen of the United States, owes permanent allegiance to the United States. So, if you're not an elected official, you're not a citizen. You could be one of the people, right? But we don't necessarily identify as a national. It in essence would actually be by virtue of holding of office that you get this term national. And it comes from right here. This is the definition of a national, which is under or made pursuant to the Constitution, right? So this would only apply to those who would be bound by it. You can't just change your status to a national. And then who in the heck would want to change their status to a national as a citizen of the United States, the corporation? Because that's not even government. Or did we forget that part? And then want to talk about where this is coming from. What's the subject matter? Oh, immigration and nationality. Huh. Well, I'll be darned. All right, so there's a question out there on Telegram. Which author should we get if we buy this book, The Law of Nations? There's only one author, Emer D. Vattel. The only one. Now, there's different revisions. Awesome. Well, good to see that you're available to tune in tonight, my friend. My special friend. Now, I keep trying to pull this up, and I getting sidetracked. And forget what I was actually going to pull up. Oh, yeah, that's right. I was going to pull up some law dictionaries because let's go with Bouvet's Law Dictionary from 1856. Now, this is 1856, right? Let's go down here and see if we can find the definition for a national. I mean, in 1856, and Bouvet's Law Dictionary, especially this one, is a really good dictionary. Whoops. How come I can't find national in Bouvet's Law Dictionary from 1856? It doesn't exist. I mean, national or public domain, like when we go to the etymology, what it talks about. All the property which belongs to the state is comprehended under the name of national or public domain. Care must be taken not to confound the public or national domain with the national finances or the public revenue as taxes, imposts, contributions, duties, and the like, which are not considered as property and are essentially attached to the sovereignty. Now remember, the people, the body politic is the sovereignty. Huh. So, national doesn't exist there. Well, let's go. Let's take a look at Black's Law Dictionary, 4th edition. Is that going to open up here or what? Now, honestly, I haven't looked in this one, but 1891. It's probably actually going to be in here because, remember, etymology. Copyright looks like in 1968. Oops. Let me grab that and just jump down here. I wonder if it'll fall in line with etymology. Naturalization. Come on. Moving slow here. Glitchy. Here we go. There's national. Pertaining or relating to a nation as a whole. Commonly applied in American law to institutions, laws, or affairs of the United States or its government, as opposed to those of the several states. The term national is used in this phrase, national of the United States, is broader than the term citizen. That's because it is by virtue of holding office. So the president, when he's a man, becomes president, elected as president. Once he is elected, he becomes a national of the United States. But again, remember the time frame. This is after the Reconstruction Acts. So, what's this right above here? In American constitutional law, the word state is applied to the several members of the American Union. Again, there's them word, members. While the word nation is applied to that whole body of the people embraced within the jurisdiction of the federal government. Okay. So, which would still be the body politic, which would encompass all of it. Oh, I guess that's probably going to be under word nation. Yeah. Nation, a people or aggregation of men existing in the form of an organized, what's that? Jural society? Now, we're going to dig in. Let's see if I have it in the right place here. Yes. All that. State, state, and state. The three different states. Now see, there's the other thing too, is we're dealing with today the state, in writing in all capital letters, state, or uppercase state and lowercase state. We read it even in the Constitution. Lowercase state or an uppercase state or all capital letters, which, again, that would be sign language. It's not to be imported into any language. Use the use of all capital letters. Okay, so this is Volume 7 of the Federal and State Constitutions, Colonial Charters, and other organic laws of the states, territories, and colonies now or heretofore forming the United States of America. That is the entire title of these 7 volumes. Okay, it has pretty much the entire history of America. Okay, this just has to do with America. All these documents. And this is the Francis Newton Thorpe. Now, this was compiled and edited under the Act of Congress, June 30th, 1906. I wonder what was going on. So, we're going to go down here to start with Virginia. What's this? The first charter of Virginia, 1606. Well, imagine that. 1606, huh? Grant to Sir Walter Raleigh in 1584. See page 53. Huh. But I thought the Mayflower, 1620. No, 1606, Virginia came first. And then not only that, when you read the Mayflower Compact, all it says is they've settled in the territory of Virginia, because we have to comprehend the metes and bounds of the territory of Virginia at the time. And that's a good one to try and figure out. But it encompassed what we now consider 7 of the states of the original 13 colonies. That's right. Within the territory of Virginia, because Virginia was first, which is why we have to comprehend that the Virginia Declaration of Rights and the Virginia Constitution, the Lee's Resolution, June 3rd, which I'm surprised, well, I don't know, the Lee's Resolution, June 3rd, which 3 short sentences which separates us from Great Britain. That's the document, not the Declaration of Independence. The Declaration of Independence is declaring the causes for the separation and declaring those acts of a tyrant, our enemy, and declaring the characteristics and conduct of our enemy, because treason is giving aid to our enemy. How do we know who our enemy is? Without declaring it. You have to declare who the enemy is. And so they did. So we have June 3rd, the Virginia Declaration of Rights, Lee's Resolution, June 3rd, 1776. Then we have the Virginia Declaration of Rights, June 12th, 1776. The Virginia Constitution, June 29th. Now that's the Constitution that creates our distinct three branches of government. And then the Declaration of Independence, July 2nd. Everybody says, oh, July 4th, July 4th. And then it wasn't even completely signed and ratified until August 8th. There's a little tidbit of history that you may not be aware of. So, and then again, the language that we will find here in the Virginia Constitution of June 29, 1776 is where the Declaration of Independence comes from. So we have to comprehend that these are all one document, really. I mean, it's like the Constitution and the Bill of Rights. It's really, they might be separate documents, but they're one and the same. And just to kind of give a little credence to this, because I know people have a hard time believing this stuff unless I show you something. Well, actually, let's just go back to this here, aside from the ninth. You know, we talk about our rights here, the Sixth Amendment, right to a speedy trial. We're going to go here to see explanation. And let's see how much they've changed this since the last time I was here. Historical background. Oops, that's the public trial I want to go to. Historical background on speedy trial. All right, so this is the historical background on the right to speedy trial in the Bill of Rights. Remember when I keep saying that our rights came long before government? This is what's known as succession of law, rights as the law. And through succession of law, rights cannot be diminished. Because think about like building something, and you lay this particular thing down, and then, we're going to build some more. We don't get to change what we've already built, what we've already laid down. That would be fundamentally altering the law of creation. So, the Magna Carta declared, we shall not, Notice they cut this out, because this used to say, we will not sell, to no man will we sell, to no man will we deny or delay justice or right. This, neither the end, that's not even there. That's all been changed. Whereby we attain to the end, and that is the law. Number 1, Chapter 40 of the Magna Carta. Portion of Chapter 29 of the 1225 reissue. Then there's the 1226 reissue. But when we go to that Cloffer versus North Carolina, which I actually might have that pulled up somewhere, unless I closed it. But because I was going on reading that. What does it say? Much of the same language was incorporated into the Virginia Declaration of Rights of 1776. Now, what does that say? 7F Thorpe. Federal and State Constitution, House Doc number 359th Congress, 2nd Session, 838-13, 1909. 7F Thorpe. That's the 7th volume, written by Francis Newton Thorpe, the Federal and State Constitutions. Oh, that would be what we were just reading from, which we're going to go back to. But why is this saying that through succession of law it goes from the Magna Carta to the Virginia Declaration of Rights and from there into the Sixth Amendment? Wait a minute. Magna Carta, Virginia Declaration of Rights, then into the Sixth Amendment. And I've had people, the Magna Carta that doesn't apply here. That's not law. Yeah, it most certainly is, because rights are the law. Now, there might be certain parts of it that don't apply here, but remember, in 1606, they brought with them the common law of England, and only those parts that were conducive to our public weal here. So this is where we started the American common law, where we started doing things the American way in 1606. Okay? So, here's some evidence to prove the history of this right, this particular one, in the Sixth Amendment. Goes from the Magna Carta to the Virginia Declaration of Rights, June 12, 1776, into the Sixth Amendment. Now, I want to show you something real quick here, because we know right here, right now, the history, that's the historical background of the right to speedy trial. We just all witnessed this, read it right from this is called the U.S. Constitution Annotated. This is the annotated Constitution, annotated, right, through case law or history of law, written by Juris Doctorates, JDs. Okay? So, here we know the right to speedy trial goes from Magna Carta, Virginia Declaration of Rights, and into the Sixth Amendment. Now, what about the right to a trial by jury? Wait, that's also Sixth Amendment, isn't it? The right to a trial by jury. Speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed. Huh. Would that be territorial jurisdiction, the locus jurisdiction? Location? Of the state and district wherein the crime shall have been committed. Which district shall have been previously ascertained by law, bylaws, and to be informed of the nature and cause of the accusation. The nature. Is this criminal in nature or civil in nature? Or is it mala prohibita, prohibited by law? Or mala in se, as in God's law, morals, like murder, rape, kidnapping, abortion, breaches of the peace, is mala in se. Morally wrong, from the law of nature. Do you know the difference between morally good and morally evil? Because that's the first primitive law of nature. When man is properly organized, he knows the difference between morally good and morally wrong. So, but what we're looking at here, we're going to get into this. What happened to the right to speedy trial? Or not speedy trial, trial by jury. Historical background. Let's look at this. By the time the United States Constitution and Bill of Rights were drafted and ratified, the institution of trial by jury was almost universally revered, so revered that its history had been tracked back to Magna Carta. Okay? The jury began in the form of a grand or presentment jury with the role of inquest and was started by Franquist conquistadors to discover the king's rights. Henry II regularized this type of proceeding to establish royal control over the machinery of justice, first in civil trials, then in criminal trials. Trial by petite jury was not employed at least until the reign of Henry III, in which the jury was first essentially a body of witnesses called for their knowledge of the case. Not until the reign of Henry VI did it become the trier of evidence. It was during the 17th century that the jury emerged as a safeguard for the criminally accused. Thus, in the 18th century, Blackstone could commemorate the institution as part of a strong and twofold barrier between the liberties of the people and the prerogative of the crown. See, this is why they instituted the jury, and more specifically, the grand jury. But between the liberties of the people and must be confirmed by the unanimous suffrage of 12 of his equals and neighbors, indifferently chosen and superior to all suspicion. The right was guaranteed in the Constitution of the original 13 states. In the constitutions of the original 13 states. Was guaranteed in the body of the Constitution and in the Sixth Amendment, and the Constitution of every state entering the Union thereafter, in one form or another, protected by the right to jury trial in criminal cases. No, it's not a jury trial, it's a right to a trial by jury. But this used to say something about 1166, which is what Aziz is, so even this has been changed a little bit. But see, what are they talking about? Constitution of the original 13 states. We're going to go back to that right now. Because Avalon doesn't want to show that. They don't show the Virginia Constitution, June 29, 1776, because they don't want us to know. And then they fundamentally altered the Virginia Declaration of Rights, June 12, 1776, to remove 12 men. Although they've shown it here. So this has changed since the last time I looked at this on law.cornell.edu. So we're going to go through a little history here. 1606. Oh, wait, what? Where did I just see something there? Restraint. Dang it. Because this particular document talks about the right to have arms while out on adventure. And we're not to be molested. So the history of the right to keep and bear arms, which shall not be infringed, even here in American common law, the very beginning, in 1606, we had the right. Let me see if I can. Can't really do a search on this because it would just bring up like nobody's business. But anyway, let's move on. It's in there. You can go read it for yourself on Avalon if you'd like. Or I need to get this out to a couple different people. Mark Bond, I know you're probably chomping at the bit for this one because this has Washington in it. But we're gonna scroll down through history here. There's 1609. So there's the next charter, 1609. So that's the second charter of Virginia. And then we have the third charter of Virginia, 1611, 1612. Ventures as planters the first colony in Virginia, and then for propagation of Christian religion and reclaiming of people barbarous to civility and humanity, we have by our letters patents, bearing date at Westminster the 3 and 12th day of May in the 7th year of our reign of England, France and Ireland, and land, and unto them they have such and all such manner of loving subjects, as should from time to time forever after be joined as them as planters and adventurers of the said plantation, and their successors forever should be one body politic. And look how it's spelt there. I might actually need to make this a little bigger for you guys. Look how politic is spelt back then. Politic. What is this? Here we go. Proof. Back to corporations or companies. Incorporated by the name of the treasurer and company of the adventurers and planters of the city of London for the first colony of Virginia, which was the Virginia Company. And whereas also the greater good and benefit of the said company, and for the better furtherance, strengthening, and establishing of the said plantation, and did further give, grant, and confirm by our letters patents unto the said company and their successors forever. See, and this is why we have to comprehend who the people are. Do you have a company? Are you incorporated into the body politic? Are you a taxpayer? Are you paying for these people? The emoluments of the offices for them to perform those specific duties? Then you're not one of the people. Sorry, that's just how our form of government works. You got to have an equitable interest in the government. Be happy, be okay with being a free inhabitant. There's nothing wrong with being man, creation of God, and assuming the powers of the earth and the laws of nature and nature's God, who intended us to be free and equal and having our own conscience. Anybody can claim that status because that status comes from God and the law of nature. Right? Man is creation of God, not creation of government. So there's no personal jurisdiction. And unless you're a member of that company, business, corporation, government, none of it applies to you. You're not bound by it or anything that's made under it. So, company and their successors forever, all those lands, countries or territories. What? Countries or territories? Situate, lying, and being in that part of America called Virginia. From the point of land called Cape or Point Comfort, all along the sea coast to the northward 200 miles. So 200 miles of the coastline belong to Virginia. That part of America called Virginia. This is 1611. This is still before the Mayflower. Okay? This is why we got to comprehend and read history. And all lying, blah, 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 within 100 miles along the coast of both the seas of the precinct aforesaid, with divers and other grants, liberties, franchises, liberties, grants, okay? Privileges, profits, benefits, commodities. These are all like commercial terms, right? For that company that's acting in foreign commerce. It's a shipping company. It's a mining company. It's a settlement company. But they wanted to secure our liberties forever. Remember, it's the good Christian people. What it says. Okay? What was the next one? Well, that's still. So see, this particular charter here is quite large, many different pages. So, and by the way, there was a couple of other countries, right? And you know, each one of these all still talk about the right to have arms. They reiterate it every single time, making sure that we have that right to keep and bear arms. Now, here we get into Ordinances, Virginia, July 24th through August 3rd of 1621. To all people to whom these presents shall come, be seen or heard, the treasurer, council, and company of adventurers, that was the other one, and planters for the city of London for the first colony of Virginia, send greeting. Know ye that we, the said treasurer, council, and company, taking into our careful consideration the present state of the said colony of Virginia, well, wait, present state? As in state of being? But still, they're still calling it a colony of Virginia? Back to the law of nations, a nation state? It's the body politic. It's not, the state is not the territorial landmass. Okay? By the divine assistance to settle such a form of government there as may be to the greatest benefit and comfort of the people, and whereby all injustice, grievances, and oppression may be prevented and kept off as much as possible from the said colony, have thought fit to make our entrance by ordering and establishing such supreme councils as may not only be assisting to the governor for the time being in the administration of justice and the executing of other duties to this office belonging, but also, see, now are we seeing citizens here? All these words, diction, come flying out at us from the historical documents about who a citizen is, administration of justice and the execution of other duties to this office. Okay? I mean, it's all over this. But also by their vigilant care and prudence may provide as well for a remedy of all inconveniences growing from time to time, as also for advancing of increased strength, stability, and prosperity of the said colony. This is government, right? We therefore, the said treasurer, council, and company, by authority directed to us from his majesty under the great seal, upon mature deliberation, do hereby order and declare, lay down the law, that from henceforward there shall be 2 supreme councils in Virginia for the better government of the said colony aforesaid. This is the American common law. How this is getting created. The one of which councils to be called the Council of State, and whose office shall be chiefly by assisting with their care, advice, and circumspection to the said governor, shall be chosen, nominated, placed, and displaced from time to time by us, the said treasurer, council, and company, and our successors. So instead of by the king, they're changing it and going, no, we're going to do this by us. Not by the king, by us. We got this. We have this power. We're the sovereign body politic, the power to create. This is what they're even creating right here, right? Which council of the state shall consist for the present only of these persons, and notice it's a capital P. That would be the 2 councils, the Council of State, and whose office, see, that's the person. As are here inserted, Sir Francis, Governor of Virginia. Oh, we had a governor of Virginia in 1621? Imagine that. See, our form of government didn't just form overnight in 1776. All throughout the 1600s. Slowly and carefully created this government. A one-of-a-kind government. There's a lot of history. A lot of history behind our Republican form of government. And lastly, in maintaining the said people in justice and Christian conversation amongst themselves, and in strength and ability to withstand their enemies. Catholicism. And this council to be always, or for the most part, residing about or near the governor. Okay, so we're getting a... Oh, wait. This is good. The other council, more generally to be called by the governor, once yearly and no oftener, but for very extraordinary and important occasions shall consist for the present of the said council of state and of 2 burgesses out of every town. That's kind of like 2 representatives. 100 or other particular plantation to be respectively chosen by the what? Inhabitants, which council shall be called the General Assembly. I'll be darn. Some history of law that points to what is called the General Assembly. All matters shall be decided, determined, and ordered by the greater part of the voices then present, reserving to the governor always a negative voice. And this General Assembly shall have free power to treat, consult, and conclude, as well of all emergent occasions concerning the public weal of the said colony and every part thereof, as also to make, ordain, and enact such general laws and orders for the behoof of the said colony and the good government thereof, so it's for them, as shall from time to time appear necessary or requisite. What does that say? In times of emergencies, it's supposed to be done by the General Assembly. See, the executive branch doesn't have the power to just declare this state of emergency and then take over. No, that has to be done by the legislative branch. And here it is in history showing us in 1621 how this works. Okay. Oh. Whoa. We skipped right over the Virginia Declaration of Rights. Where is it? What the heck? Let's see here. Things require the said General Assembly, as also the said Council of State, to imitate and follow the policy of the form of government, laws, customs, and manner of trial, and other administration of justice used in the realm of England, as near as may be, even as ourselves, by His Majesty's letters patent, are required. Now, remember, this was written by Francis Newton Thorpe, and he used the word Y there, or letter Y. Instead of police, what we think is police is actually pronounced policy, which when we get into some of these other 1776 constitutions, you'll see it was spelt Police, like citizen or city, E. When you say the letter E, it's E. So policy, that should be an E there, not a Y. But more trickery. Even though, company, colony. Now, this is weird. Okay, maybe it's, it has the Bill of Rights right here in the Constitution of Virginia. See, let's just read. A Declaration of Rights made by the representatives of the good people of Virginia, assembled in full and free, convention. Now, again, remember the size, the territory of Virginia. Verified from ordinances passed out of the General Convention of Delegates and Representatives from the several counties and corporations of Virginia, held at the capital of the city of Williamsburg on Monday, the 6th May, 1776. Now, the proceedings of the Convention of Delegates for the counties and corporations in the colony of Virginia. Remember, of the people, by the people, for the people? Okay. So this is so crucial to our history here. At the root, founding document. This is it. This is the first document after the separation. And when we do a nation, you gots to declare its ideology. The law of the nation is its principles, its ideology, morals. Where do we get that from? From religion. And so this also debunks that separation of church and state, because it's like, how do we have a nation without declaring our ideology? The root. Those fundamental principles of the law of nature. You have to do this. That's the way it's done. And this is a declaration. And see, this is saying the Constitution of Virginia. No, it is not. This is the Virginia Declaration of Rights. June 12th, 1776. So Francis Newton Thorpe is trying to confuse us, saying that this is the Constitution. See, back then, declarations were separate from constitutions, because declarations of rights laid down the law. Then they did the Constitution, or frame of government, because the Constitution's for the government, and the Bill of Rights is the law. That's the true law. Merely declaratory of the common law. So, this doesn't even say Article 1. Maybe this is the beginning. Wait. Declaration of Rights made in a free convention, which rights do pertain to them and their posterity as the basis and foundation of government. That's because Virginia was the leader to begin with and held pretty much all of the power here in America. Okay? So let's move on down to where it says, oh, see, now they're saying Section 1. Well, let's just take a different look for a half a second here. And I don't have my Annals of America book here with me. It's at the office. Let's see, 1 out of 15. See, the Constitution of Virginia, June 29th, 1776. There's Declaration of Rights of Man, 1789. Draft Constitution. Declaration of Independence. Where's the Virginia Declaration of Rights? I bet it's down here. It is. I know it is. STUV. See, there we go. These are articles. 1. These are in Roman numerals. Now, before we leave here to go back over there, let's look at this again. Right here. Section 8, or Article the 8th. That in all capital criminal prosecutions, a man has the right to demand the cause and nature of his accusation, to be confronted with the accusers and witnesses. So this right still stands today, folks. Now remember, we talk about the right to a trial by jury and a speedy trial. Right here. This is what it's talking about. This is the Virginia Declaration of Rights. To call for evidence in his favor and to a speedy trial by an impartial jury of his vicinage, without whose unanimous consent he cannot be found guilty. Now, unanimous consent, which means all 12 have to give their consent for finding guilt. That beyond a reasonable doubt standard comes from right here, which if there's one of them that says, I'm just not quite convinced, that's not a hung jury. That's an acquittal. You didn't get consent of finding him guilty because you didn't convince all 12 men. But notice they leave out 12 or 12 men. Speedy trial by an impartial jury of his vicinage? Of what? Oh, wait a minute. Maybe Francis Newton Thorpe put it in here. Let's go to Article 8, or here's Section 8. That in all capital criminal prosecutions, a man hath the right to demand the cause and nature of his accusation, to be confronted with the accusers and witnesses, to call for evidence in his favor, and a speedy trial by an impartial jury of 12 men of his vicinage, without whose unanimous consent he cannot be found guilty. Why did you take out 12 men? Well, in misdemeanors we can do 6. No, you cannot. That's subversion of the right. You're subverting the law. Here is the law being laid down, declared, meaning down, clarifying, by putting it in writing. Law, that which is laid down. This lays down the law. Now, Hale versus Hinkle talks about our rights are long antecedent to the formation of the state, the body politic. That's right. This is one of those times. Okay? And nor can he be compelled to give evidence against himself, that no man be deprived of his liberty. What? Except by the law of the land, or the judgment of his peers. It doesn't say statutes or bylaws or whatever. No, by the law of the land, or the judgment of his peers, which you've got to get unanimous consent from all 12. And if there's one of them that just doesn't give their consent, you lose. You can't put them in jeopardy twice for the same thing. You get one shot, one trial. And it's supposed to be a trial by an impartial jury of 12 men of our vicinage. Okay? Something about reading. Reading means reading. How about this one? That all power of suspending laws or the execution of laws by any authority without consent of the representatives of the people is injurious to their rights and ought not to be exercised. That's, when the governors declared this so-called state of emergency under natural catastrophe, which has to do, according to the code, has to do with volcanoes and earthquakes and water waves and tsunamis. It has nothing to do with communicable diseases that causes catastrophic damage. But anyways, declaring a state of emergency and then suspending it, spending these laws, and those of you that caught the video footage of me down there at the Capitol with that lobbyist whose woman was trying to be all nice to me, and but the governor suspended these 50, 75 points of law. No, and that's what I was talking about. Do you even know what you're talking about, woman? The governor doesn't have that power. Right here. You don't get to suspend the law. You have no authority to suspend that, governors. None. The power doesn't exist. This is a right to a Republican form of government here. Declaration of Rights. This is theoretical foundation of all government. And that's what it says in Annals of America, Volume 2. 7S Thorpe is the source and says it's theoretical foundation of all government. Because this was done in convention. That's how it's done. How about Section 13, that a well-regulated militia composed of the body of the people trained to arms is the proper, natural, and safe defense of a free state. That standing armies in time of peace should be avoided as dangerous to liberty, and that in all cases the military should be under strict subordination to and governed by the civil power. So who is the militia again? The right of the people to keep and bear arms shall not be infringed, because the militia is the people. And the military is to be under strict subordination to and governed by, that's that well-regulated militia, the civil power, the people, the body politic. We didn't give them subject matter jurisdiction over our arms. None. Congress has no subject matter jurisdiction over any of our rights. Oh, but we do. We no. You only have the power to make legislation based on the subjects that we delegated to you. That would be Article 1, Section 8. The power is delegated to Congress. That's subject matter jurisdiction. Nowhere in there does it talk about any of our rights. None. Because that's a body of law that's outside of government. Government was instituted to secure those rights from infringement. Like that the freedom of the press is one of the greatest bulwarks of liberty and can never be restrained but by despotic governments. So for you folks out there that are like First Amendment auditors and stuff, you ought to really gobble this one up. What's a despot? It's a tyrant. Tyranny. So, the liberty of the press or freedom of the press goes with the right to freedom of speech. And it is one of the greatest bulwarks of liberty. And it can never be restrained but by despotic governments. Why? Why are you restraining our right to freedom of speech and the right to, just because technology changes does not mean the right changes. We have every right to video inside of a courtroom at any time because there is no reasonable expectation of privacy. None. Because courts are supposed to be open. Anybody can walk in there. So if any man can walk in, he can walk in with a video camera or an audio recorder. And that cannot be restrained except by despots or tyrants, which is what's declared in the Declaration of Independence. Tyrants. So now, we're ready to, let's do section 16 here. That religion, or the duty which we owe to our Creator, and the manner of discharging it, can be directed only by reason and conviction, or logic and reason, not by force or violence. So this is the very clear limitation on government right from the get-go. The government is not authorized to use force or violence against us. You have to use logic and reason. And you got to follow the law of the land, due process of law. And you cannot deprive any of our rights without following the law of the land or the consent of a jury. Don't touch me there. And therefore, all men are equally entitled to the free exercise of religion, which is what? Conscience. Wait. According to the dictates of conscience. In other words, freedom of choice. That's what religion really is about, is conscience, constitution. We have our own constitution, our own conscience. And that it is the mutual duty of all to practice Christian forbearance, love, and charity towards each other. As the theoretical foundation of all government, that sure sounds like it's declaring the law of the nation as Christianity, as our ideology in this nation called America. That's a fact of law, as it is written right there. Not my opinion. Now, this is where we get into where it says, the Constitution or form of government agreed to and resolved upon the delegates and representatives of the several counties and corporations of Virginia. Again, how many different colonies were within the territory of Virginia at this time? Lots. Okay. Whereas George III, King of Great Britain and Ireland, and Elector of Hanover, heretofore entrusted with the exercise of the kingly office of this government, hath endeavored to prevent the same into a detestable, insupportable tyranny, by putting his negative on laws the most wholesome and necessary for the public good. So, the people were trying to create good stuff to protect themselves, and of course, the king would veto it, or his negative. By denying his governors permission to pass laws of immediate and pressing importance, unless suspended in their operation for his assent, and when so suspended, neglecting to attend to them for many years. This is the Constitution. June 29, 1776. This is not the Declaration of Independence yet. By refusing to pass certain other laws unless the persons to be benefited by them would relinquish the estimable right of representation in the legislature. You know, like the right to petition, the right to alter, reform, or abolish anything at any time we deem it necessary. How about this one? By dissolving legislative assemblies repeatedly and continually for opposing with manly firmness his invasions of the rights of the people. That's right, straight out of the Declaration of Independence. But see, this came before the Declaration of Independence. When dissolved, ooh, sucker, by refusing to call others for a long space of time, thereby leaving the political system without any legislative head. So see, he was dissolving those general assemblies, even though clear back in 1606, 1609, 1611, that they had made it to where they get to pick those guys. Again, this is the American history of the American common law versus the English common law, the separation. And this is the king coming in and trying to subvert and squash what they're building and how they're formed, how they chose to be governed by charter, by endeavoring to prevent the population of our country, and for that purpose obstructing the laws of naturalization of foreigners, by keeping among us in times of peace standing armies and ships of war. By effecting to render the military independent of and superior to the civil power. That's that police force. By combining with others to subject us to a foreign jurisdiction, giving his assent to their pretended acts of legislation. For quartering large bodies of armed troops among us, for cutting off our trade with all parts of the world, for imposing taxes on us without our consent, for depriving of us of the benefits of trial by jury, not jury trial, trial by jury, for transporting us beyond seas to be tried for pretended offenses, for suspending our own legislatures and declaring themselves invested with power to legislate for us in all cases whatsoever. In all cases whatsoever. The common law, we didn't need them to legislate for us. Murder's already the law. We know murder. We don't need legislation for that. Common law. Common sense law. But see, again, this is the Constitution. June 29, 1776. This is not the Declaration of Independence. This is why we have to comprehend these documents. By plundering our seas, ravaging our coasts, burning our towns, and destroying the lives of our people. By inciting insurrections of our fellow subjects with the allurements of forfeiture and confiscation. By prompting our Negroes to rise in arms against us, those very Negroes whom, by an inhumane use of his negative, he hath refused us permission to exclude by law. Wait a minute. How do the Negroes have arms? If everybody didn't have the right to keep and bear arms. By endeavoring to bring on the inhabitants of our frontiers, and actually, I'll kind of answer that because they were supplying arms to the slave owners, and the slave owners were getting the slaves to fight on their behalf. And these were the insurrectionists. By inciting insurrections of our fellow subjects with the allurements of forfeiture and confiscation. Those are those bills of attainder, bills of pains and penalties. Well, if you guys go against your fellow guy over here, who's pushing this good law and protecting the good Christian people and protecting people's rights and blah 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 blah, we'll give you a chunk of their land and their home and their cattle and whatever. That's what was going on. Internal insurrection. By endeavoring to bring on the inhabitants of the frontiers of the merciless Indian savages, whose known rule of warfare is an indistinguished destruction of all ages, sexes, and conditions of existence. Okay? Again, the same thing. They were getting the Indians to go against the good Christian people. And there were definitely Indian tribes that didn't care. They killed their own people. They killed anybody. But we had, the history, they try to teach us that, the white man came over here and stole their land. No, it's not exactly entirely true. That's one of them half-truths. And then again, who is it that we're actually talking about that was doing that? Because the good Christian people made friends with some of the Indian tribes when they first landed here. And in fact, the very first ones, they probably would have all died without the help of the Indians. And I'm talking about in 1603, when Jamestown, Virginia was first established, with the first charter of Virginia in 1606. Now, some of that's changed out there, saying, that wasn't until 1609. Well, yeah, how do we have the first charter of Virginia in 1606? Without first establishing the territory. Whoops. But here we go. This is what's in writing here. By transporting at this time a large army of foreign mercenaries to complete the works of death, desolation, and tyranny, already begun with circumstances of cruelty and perfidy, unworthy the head of a civilized nation. By answering our repeated petitions for redress with a repetition of injuries. What are they saying here? That they petitioned for redress? And they were only met with repeated injuries. And finally, by abandoning the helm of government and declaring out of his allegiance and protection, by which several acts of misrule, the government of this country, as formerly exercised under the crown of Great Britain, is totally dissolved. Again, June 29th, 1776. before the Declaration of Independence. So we're being lied to today. Oh, well, the Declaration of Independence, that's the document. That's the document. No, it's not. It's this one right here. It's the Lee's Resolution. The Virginia Declaration of Rights is the theoretical foundation of all government. And this Constitution right here. This is the first Constitution here in America. The nation called America. As it has been what? Totally dissolved. Can't get any more clear than the writing of the document itself, can ya? We, therefore, the delegates and representatives of the good people of Virginia, having maturely considered the premises and viewing with great concern the deplorable... deplorable? Isn't that what they've been calling us for the last 5-6 years now? A bunch of deplorables? Deplorable conditions to which this once happy country must be reduced unless some regular, adequate mode of civil polity is speedily adopted and in compliance with the recommendation of the, what? General Congress, do ordain and declare the future form of government of Virginia to be as followeth. The legislative, executive, and judiciary department shall be separate and distinct, so that neither exercise the powers properly belonging to the other, nor shall any person exercise the powers of more than one of them at the same time, except the justices of the county courts shall be eligible to either house of assembly. Either house of assembly. The legislative shall be formed of two distinct branches, who together shall be a complete legislature. They shall meet once or oftener every year and shall be called the General Assembly of Virginia. There's that darn General Assembly again. One of these shall be called the House of Delegates and consist of 2 representatives and be chosen for each county and for the district of West Augusta annually, and of such men as actually reside in, and are freeholders of the same, or duly qualified according to law, not by law, but according to law, and also of 1 delegate or representative to be chosen annually for the city of Williamsburg, and 1 of the borough of Norfolk, and representative. See how this is all getting laid out, our Republican form of government here? The other shall be called the Senate. So this is the 2 parts of the House, or General Assembly, and consist of 24 members, there's that key word again, of whom 13 shall constitute a House to proceed on business, for whose election the different counties shall be divided into 24 districts, that district previously ascertained by law, right there. And such county of the respective district at the time of election of its delegates shall vote for 1 senator who is actually a resident and freeholder within the district, or duly qualified according to law, not by law, and is upwards of 25 years of age. Oh, what's this? And the sheriffs of each county within 5 days at farthest after the last county election in the district shall meet at some convenient place, and from the poll, so taken in their respective counties, return as a senator the man who shall have the greatest number of votes in the whole district. That would be the sheriff that's supposed to bring that man as a senator per the election in the district. I'll be darned. That would be the sheriff that's supposed to do that. To keep up this assembly by rotation, the district shall be equally divided into 4 classes and numbered by lot. At the end of 1 year after the general election, the 6 members elected by the first division shall be displaced, and the vacancies thereby occasion supply from such class or division by new election in the manner aforesaid, before the sheriff. And see, this is that's that term limit right there. Out of that 34 or whatever. Okay, we still do this today. That's how we rotate that around. Still to this day, as a fundamental principle of our form of government, laid down or ordained and established right here in 1776. That's how we do this. They rotate around 3 different classes. Or was it 4? Anyways, that's how this is done. It's laid down right there. The right of suffrage in the election of members for both houses shall remain and exercised at present, and each house shall choose its own speaker, appoint its own officers, settle its own rules of proceeding, and direct writs of election for the supplying of intermediate vacancies. This is the General Assembly. The legislative branch does this. All laws shall originate in the House of Delegates to be approved or rejected by the Senate, or to be amended, with consent of the House of Delegates, except money bills, which in no instance shall be altered by the Senate, but wholly approved or rejected. So that's supposed to be done in the House. Well, it is the House. House of Delegates. A governor or chief magistrate, shall be chosen annually by joint ballot of both houses, to be taken in each house respectively, deposited in the conference room, the boxes examined jointly by a committee of each house, and the numbers severally reported to them, that the appointments may be entered, which shall be at the mode of taking the joint ballot of both houses in all cases, who shall not continue in that office longer than 3 years successively, nor be eligible until the expiration of 4 years after he shall have been out of that office. So in other words, you run, you get elected, you sit in there, in this case, for 3 years, then you got to sit out for 4 years, and then you can qualify to be reelected again. So they did have some safeguards in place right from the get-go, so they didn't end up with some jackwagon in there for a continued amount of time. An adequate but moderate salary shall be settled on him during his continuance in office, and he shall, with the advice and counsel of the state, exercise the executive powers of government, according to the laws of this commonwealth, and shall not, under any pretense, exercise any power or prerogative by virtue of any law, statute, or custom of England. This is the law being laid down here. Statute or custom of England? But he shall, with the advice and the counsel of the state, have the power of granting reprieves and pardons, except where the prosecution shall have been carried on by the House of Delegates, or the law shall otherwise particularly direct, in which cases no reprieve or pardon shall be granted, but the resolve of the House of Delegates. I mean, this is telling us right there that the legislature does prosecutions. Why we're supposed to be petitioning the legislature for the redress of grievances. It's quite amazing when we read history of law and the founding documents of our nation called America. Either house of the General Assembly may adjourn themselves respectively. The governor shall not prorogue or adjourn the assembly during their sitting, nor dissolve them at any time. Remember, they were having an issue with the governors and the king dissolving their legislative assemblies. But he shall, if necessary, either by advice of the Council of State, hey, there's that Council of State that was created clear back in 1611, or on application of a majority of the House of Delegates, call them before the time to which they shall stand prorogued or adjourned. Oh, you mean we could call them? We could call them in to assemble? Would that be by petition? Would a petition peaceably assemble them so that we can consult for our common good? And then would We get to instruct our representatives to discharge the duties of the office and grant relief. I don't know. How about prosecute the public servant that we're telling on? In the legislature, not the judicial. Whoops. Okay, I went really long tonight. There's so much more to this, but this one lays out the three distinct branches of government. And again, I've just proven to you, whoa, and it says Constitution of Virginia of 1830. I just proved to you that history of law, the actual documents here in creating the nation as a theoretical foundation of all government, before the Constitution, or before the Declaration of Independence. Remember that succession of law that I showed you earlier. Okay? Right? All right. Whew. So, now you know, right? Y'all grasp this concept of form of government at least a little bit more? And you can't change your status to a national. And I'll challenge any man to a debate on that. Bring your books and bring your papers, and you better bring something a whole lot higher than what I just brought, which you can't. Good luck. So that should end the argument on whether or not you need to change your status. Okay? Should answer everybody's question out there. Do I need to change my... No. You're man, creation of God. Why would I need to change my status? I can claim and declare in my notice of special appearance, I can do an affidavit of status and go file it at the county recorder's office and turn around and get a certified copy of that and take it over to the Secretary of State, file it over there, turn around and get a certified copy of that. Then if I really wanted to go balls out, I'd send it all the way over to the Secretary of State Federal, file it over there, and then turn around and get a certified copy of that. So that would be one document with 3 certified certifications on it. Both county, state, and then federal. Now, ask Tony Pellegrino about that, because he did it at the county level, and then he used his affidavit of status to get on a plane and fly to Pennsylvania. So I don't want to hear any guff out there about how that doesn't work, because it does. And I'm actually getting ready to go do that myself. So I've prolonged it for many years, but I think it's time to do it. Doing that affidavit of status and taking it over to the county recorder's office, recorded it, turn around and get a certified copy, take that certified copy, file it with the Secretary of State at your state level, turn around and get a certified copy of that, take that certified copy, take it over there and file it with the federal Secretary of State, and turn around and get a certified copy of that. That will do me good wherever I go worldwide. I don't need a passport. That's my ID. I am man, creation of God. I'm an American. I was born of my father and mother. Okay? I was not birthed like a ship. So, anywho, Okay, let me one last little tidbit. The 14th Amendment. 14th Amendment was for the freed Negro slaves. Okay, there aren't any freed Negro slaves that are alive today. And not only that, that's all Reconstruction Act era crap. And again, why do I have to actively engage in the fraud to get out of the fraud when fraud vitiates everything from its inception, void ab initio? I don't care what they did back in 1871. I am man, creation of God. Can you rebut that? Anyone out there that wants to debate me on this, hit me up. Send me an email, kirk@kirkslawcorner.com. Send me an email and tell me about your how you think everybody needs to change their status. We can do a debate on it. Bring your books, bring your papers, and be advised. Fraud vitiates everything from its inception. Contract Law 101. Fraud vitiates a contract. Under duress, threat, or coercion, any kind of artifice, trickery, scheme, scam, fraud. Okay. Bye-bye, 14th Amendment. And it's not an amendment. They are supposed to be articles in addition to. No, I don't send anything to Trump. For those out there, oh, you send to Trump, Blinken, and 2 others. No. I don't care if you've done it or not. You need to go back and watch the law that I just put out there today. Or tonight. So. No. I don't need a passport for traveling in my personal property. I have the right to acquire, possess, and utilize my personal property how I see fit. Can you rebut that? I am man, creation of God. Can you rebut that? No. I have the right of personal liberty, which consists in the power of locomotion. Choo-choo, vroom vroom. Can you deny that? Can you rebut that? No, you can't. These are my rights. They come from the law of nature, fundamentally and principally, and anything that comes in conflict with those rights is void for any effect for fraud. Get it? Because that's how that works. Fraud vitiates everything from its inception. Void ab initio. From its inception. Void. For any effect. Ever. Period. Kick rocks with that garbage. I don't need permission from another man to exercise any of my God-given rights. Ever. Much love, everybody. And that's all my passion, right? I have passion for these rights, the same rights that you have in common. This is the common law. At the root of all law, the law of nature, is the common law. Because those rights come from the sovereign, the creator of all things. Mankind being one of those things that got created by God, and we are endowed by God with our certain unalienable rights. Among those unalienable rights, among them, it's not all of them. Let's just touch on those certain ones: life, liberty, and the pursuit of happiness. Now, anything created by man that comes in conflict with those 3 basic fundamental principles of law is void for any effect, for fraud. Or otherwise, it wouldn't be a principle, it wouldn't be unalienable, because rights are our property, as property is an aggregate of guaranteed rights. That's why the rights are the law, the common law, which comes from the French word droit. I know that one. I might even be saying that one wrong. In English, it looks like it says droit, which means law or right. Rights are the law. So there you have it. So with that, For those of you that would like to help support over there on, get on my Patreon, Tier 1, Tier 2, 5, 10, or you could do whatever you want. You don't have to actually enter a tier. You could just say, I want to give Kirk $25 a month. There you go. You can put that in there however you want. So, I would greatly appreciate that, and I appreciate those that are over there now. And if you want to get in on the Wednesday night workshop, well, that's Tier 3. If you want some one-on-one time with me, that's Tier 4. Now, another thing we can do, if you want more than 1 hour per month, you can go in and change your pledge, and that's how that will work. Now, given that the way that they're doing that now on Patreon, so that would be cool if that's how we can make that work. Otherwise, I'm going to put out that Patreon for those who want to go over there. And let's see, on Facebook. Oh. And of course over here on Telegram. And now the Facebook. Alright, so that's how you can help support me. Otherwise, it's just over at the office at 6477 West Fairview Avenue, Boise, Idaho, 8370. Oh, I forgot Suite C. Oh, is it not going to let me? Will it let me copy? No. You turd. Won't let me. Oh, yes it will. I got a hold of it. Okay, so I'll put that address out there for those that would like to help support by sending it through the postal mail or however, you know, those postal money orders. Michael, I did receive your letter. Thank you, brother. And Diesel D's, I received that tiny little old book. Holy smoke, it's so fragile. Why doesn't it have... Well, I can just put it in there, I guess. It doesn't have the zip. Cash wrapped in aluminum foil, anything like that, gold, silver coinage, any gifts you'd like to send. It's been a while since I've been on here, so people probably stopped following for a little bit, but come on. Why are you doing this? There we go. Thanks, Fix It Fast. Right, just as I finally got it to work. Okay. So yeah, there's the address for over at the office. And you're welcome, Lance. I see you over there in Telegram. I spent almost 2 hours on the phone with that man. We're getting ready to start filing our lawsuits and petitions to the legislature and criminal complaints. We are right on the verge. Again, we've already got a lot of our stuff drafted. We have our Title 42s drafted. We have our criminal complaints drafted. And, you know, the beauty of all of this is the statement of facts of who did what, where, and when is the same no matter where we go. So that's the hardest part of doing all of this, is doing the statement of facts of who did what, where, and when, based off of the evidence that we have gathered, which is every single paperwork document, starting with the first proclamation declaring a state of emergency, everything from the Department of Health and Welfare, everything from every single Board of Health in Idaho, everything from every city mayor, everything from every county commissioners. Yep, we have it all. Every single document they put out. Who did what, where, and when. And a statement of facts based on those documents of who did what, where, and when. It's It's our turn. It's my turn. So, just to let everybody know, that's going to get a little expensive. So, I'm looking for help and funding on that because we're going to need it. It's going to get quite expensive when we go filing the lawsuits and doing all these depositions, and who knows what else is going to come down through the line on that. But I'm doing this for everybody, right? What I've been teaching, Chris and I have been trying to teach you for years. You know, when you get standing in a cause of action, do this in a way that it does it for everybody. Shut it down for everybody. Don't just try to defend yourself at your local court and take your win and run. Keep going. File that petition. File a criminal complaint. File your lawsuit. Okay? Follow due process of law. So, that's right. It's time to turn the tables on the money changers. I've had enough. I'm done. And I've waited patiently. There's a lot of stuff I'm going to be banging out in the Idaho legislature this legislative session. I've been holding off. I've been waiting. And, well, Michelle, is that the link to the Telegram channel that you just put in there in the comments? I was going to say, still, after I end the live here for YouTube, Facebook, and Rumble, still be live over here on the Telegram channel. I think it is. I hope it is. So I'm going to put that on YouTube. Hopefully that is my link to my Telegram and Facebook. So if you'd like to join us in the after show over here on Telegram, you are more than welcome to join us over there. Yep. Join group chat on Telegram, hopefully. Okay, so much love everybody out on Facebook, YouTube, and Rumble. Thank you all for the subscribers on Rumble. You guys are awesome. I'm still overwhelmed with how fast you folks come together. Where I hadn't been live for almost a year, and within just a very short period of time, 175 of you subscribed to my Rumble channel. So I feel the love. I really do. And thank you. Thank you all for your prayers. I really could use prayers. So I know that a lot of you have prayed for me over several years now. And this is a spiritual war. And I put on the full armor of God, believe it or not. Make no mistake. I could not do all this without the power of God behind me. So I'm answering the call, and I'm doing what I can to, one, educate my fellow man, bring unity. Okay? Get on my Telegram channel, Kirk's Law Corner. Everything's Kirk's Law Corner now, again. Whether it's Patreon, whether it's YouTube, whether it's Rumble, whether it's Facebook, or whether it's Telegram. I'm trying to bring unity. I'm trying to educate my fellow man. Bring unity so we can stand together and take action to do this, right? We one man can do a petition, but I really need more than just myself. Especially when we start going after the bar, going after the Idaho Code. When we go to take this stuff down, alter, reform, or abolish, I'm going to claim and exercise that power. And I'm going to expose the fraud. And I'm going to follow due process of law. Gonna need some support. Okay? And I'm not talking financial support. I'm talking physical man support. The people coming together, bring unity. Stand together. Put your name down as a signer. Okay? On my petition for Idaho. All right? Much love, everybody, and except for those on Telegram, hang out. We're not ending on Telegram, just YouTube, Facebook, and Rumble. Okay. Much love, everybody, and for those of you out there on Facebook or YouTube or Rumble, join us over there on the Telegram. All right. Much love. God bless, and we'll see you.